You cannot try anybody unless the law is written. Show me the written law. Show me the written law. I want law. It's not a written law. You cannot. You cannot. You can't convict me.
Hello, my people. This one is a big twist. Not loud, not dramatic, but legally explosive. Nnamdi Kanu has filed 22 grounds of appeal, and he is asking the court to quash his terrorism conviction completely. Not reduce, not adjust, erase. But the real question is, why take this route now? And what does 22 grounds actually signal? Stay with me on this one, because the part Nigerians are ignoring is the part that could change how cases like this are decided in the future. And it's not obvious at first glance. Most Nigerians heard terrorism conviction and assumed the door was locked, finished, no return. But appeals are where cases come back to life. And 22 grounds is not symbolic. That number tells you this is a full legal assault, not a minor complaint. Every ground is a separate argument, a separate pressure point. This appeal is saying something serious. The conviction itself is being challenged at its roots. Procedure, interpretation, application of law. Not emotions, not politics, law. And when a defense team lists 22 grounds, they are saying the original decision is vulnerable in multiple places. That is a bold claim inside any courtroom. But here's what many people are not asking. If the state was confident in the conviction, why does an appeal like this still carry weight? Because appeals don't fight headlines, they fight technical weaknesses, and technical weaknesses decide outcomes, quietly. Look beyond the personalities. This moment is testing institutions. Government wants finality. Supporters want relief. Citizens want consistency. But the judiciary wants correctness. Correctness can reopen settled battles. And that's uncomfortable for any nation, especially one already divided in opinion. Appeals are where power meets restraint. The state says order must stand. The defense says procedure must stand. Courts stand in the middle, and when courts hesitate or shift, confidence shifts with them. That's why this appeal is not routine paperwork, it's institutional tension. Nigeria can feel it. Here is the deeper layer. If even part of these 22 grounds succeeds, it could reshape how terrorism convictions are defended nationwide. That is the hidden impact, and very few people are talking about it. Legal precedent spreads silently. One successful appeal becomes a reference point. Future defense teams copy strategy. Future judges cite reasoning. Future prosecutions adjust tactics. That's how systems evolve. Not through speeches, through rulings. And sometimes, the case people think is about one man ends up influencing hundreds unseen. That's the scale of what is unfolding. For ordinary Nigerians, the reaction is emotional but practical. People want certainty. They want to trust that judgments are stable. Appeals remind citizens that justice is layered, not instant, not simple, and never immune to challenge. That uncertainty creates tension because stability feels safer than process, even when process is necessary. Supporters see hope reopening. Critics see risk reopening. Government sees authority being tested, but courts see something else, their legitimacy on display. Every ruling now carries weight beyond the courtroom, and judges know it. So this appeal is no longer just about Nnamdi Kanu. It's about how resilient Nigeria's legal system is when a major conviction is pushed back into the arena. I want to hear your honest view. Do appeals like this strengthen justice or weaken public trust? Because what happens next will echo far beyond this case.